जय भीम सर। सर जय भीम।
जय भीम सर, जय भीम।
हाउ आर यू सर?
फाइन फाइन सर। हाउ सर?
थैंक यू।
రాము ఏదో శ్రీధర్ గారు సార్ గుడ్ మార్నింగ్ సార్. సార్ గుడ్ మార్నింగ్. సార్ గుడ్ ఆఫ్టర్నూన్, గుడ్ ఈవినింగ్ సార్, గుడ్ ఈవినింగ్. సార్ మీది పైకి తల కిందికి పైకి అయింది సార్ కొంచెం. కొంచెం తల కింది కొంచెం ఇంకా కొద్దిగా, ఇంకా కొంచెం. సార్ ఇప్పుడు కరెక్ట్ గా. మహేంద్ర కుమార్ గారు, గుడ్ ఈవినింగ్.
वेरी गुड इवनिंग एंड जय भीम सर। मैंने तो एकदम पहले ही बोला था आपको, पर रवि सर रेस्पोंडेड।
ఫోన్ బిజీ వస్తుంది సార్.
కరణ్వీర్ जी, गुड इवनिंग, जय भीम.
सर जय भीम, नमो बुद्धाय, जय संविधान। सर कैसे हो? जय भीम सर। आवाज नहीं आ रही मेरी? जय भीम सर।
जय भीम सर, जय भीम।
अभी नागपुर से पहुंच रहे हैं सर, रास्ते में।
Sir, good evening, sir.
Is it okay now? Can you listen to me?
Yes, sir. Yes, sir. Yes, sir.
Sir, unmute చేయండి sir.
ఏం చేయాలి?
నాకు వినిపిస్తుంది సార్, వినిపిస్తుంది అన్నిట్లోనే ఉంది.
Good evening, sir.
నమస్తే సార్. ఇది క్లియర్ ఉందా బాబు? ఉంది క్లియర్ ఉంది.
రవి.
సార్ చెప్పండి సార్.
హలో.
చెప్పండి సార్.
రవి.
సార్ మీదేదో వాయిస్ తేడా ఉంది సార్, మీకు వినపడట్లేదు.
రవి.
సార్ హలో సార్.
నా మాట వాళ్ళకి ఆయనకు వినపడుతుంది.
రవి
వినపడటంలే.
అదే మన మాట వినపడలేదు సార్కి. సార్ మాట మనకు వినిపిస్తుంది కానీ లక్ష్మీ సార్కి వినపడలేదు.
నాకైతే ఇది దీని మీదనే పెద్ద ప్రాబ్లం అయిపోతుంది.
సిస్టమ్ స్పీకర్ కూడా బాగానే ఉంది కదా.
సార్ కనపడుతున్నారు ఇప్పుడు.
ఏమైంది? వాల్యూమ్ బాగానే ఉంది, వాల్యూమ్ మొత్తం పెట్టాను. ఓకే. హలో.
హలో
సార్ వినిపిస్తుంది.
హలో
సార్ వినిపిస్తుంది సార్, లక్ష్మీ సార్.
హలో.
మాట వినిపిస్తుంది.
మళ్ళీ పోతున్నాను.
హలో. మీరు స్టార్ట్ చేయండి. ప్రాబ్లం ఏమైందో తెలియదు. మూర్తి గారిని ఇన్వైట్ చేసి స్టార్ట్ చేసి, లేకుంటే నా మాట వినబడుతుంది కదా, నేను ఇన్వైట్ చేశాను. సార్, వెల్కమ్ టు 66th lecture. I think my voice is clear, but your voice is not clear to me. I'm very sorry what happened, I don't know, but now we can start this lecture. This series of Samvidhan Samalochan, 66th lecture. Topic is freedom of expression and constitutional democracy. Speaker Professor Madabushi Sridhar Garu. I think former Central Information Commissioner, and he was a professor in law universities, and he was a journalist. He wrote so many books, and he got so many medals and gold medals. I think very interesting thing is I don't want to tell you. This session will be moderated by Dr. K. Ramchandramurthy, senior editor and renowned journalist in Telugu media. And he wrote in English also in so many magazines. He edited, he was editor of English daily Hans India. Then I welcome two eminent personalities to this lecture. I request Murthy Garu should be moderate and introduction of Sridhar Garu, because Sridhar Garu and Ramchandramurthy Garu together, they worked in one Telugu daily very closely. That time Murthy Garu was the editor, Sridhar Acharyul Garu was a senior correspondent, and all those relations and bonding there with two eminent people. Thank you very much, sir. I am sorry I didn't hear, but I will join in another device. Thank you very much, sir. Thank you, Murthy Garu, and thank you, Sridhar Garu, to accept this occasion to speak. Thank you, sir.
థ్యాంక్ యూ మిస్టర్ గారు.
సార్ నమస్కారం.
మరి
నా మాట వినబడుతుందా?
నా మాట వినబడుతుందా?
వినబడుతుంది.
Yes, sir. Yes, sir.
మై వాయిస్?
Yes, sir.
Yes.
Yes, sir.
Thank you.
థ్యాంక్ యూ. గుడ్ ఈవినింగ్ లక్ష్మి గారు, శ్రీధర్ గారు అండ్ మెనీ అదర్స్. Freedom of speech and constitutional democracy. This subject today, given to Dr. Sridhar, is the most appropriate person to speak on the subject, because he worked in the newspapers, enjoying the freedom of expression, and he also worked as a law teacher, has been working as a law teacher. Siddharacharyalu, Madhavu Siddharacharyalu was a journalist until 1993, and we worked together in Udayam. First he worked in Inadu, then he joined Udayam. That's where he completed his, he did his MA, LLM, and completed his PhD, and joined Pendekanti Law College as professor of law. And he was with Nalsar University from 2000 to 2013 for 13 long years. He was both professor and registrar there. And he was Central Information Commissioner from 2013 to 2018. Professor and Dean in Bennett University in Delhi, and Dean in Mahindra University now. Advisor to School of Law, Mahindra University. He did PhD, LLM, MCJ, and LLD, highest degree in law. He delivered about 25,000 judgments as RTI Commissioner. He got 4 gold medals, wrote 64 books. One of the 64 books was about his father, Mr. M.S. Acharya, a renowned journalist, a person who grew from newspaper boy to newspaper editor. The book he wrote about his father. He was editor of the Warangal Vani Janadharma, and he was a journalist until his last, the freedom fighter. He fought against Nizam and all. And Professor Sridhar himself had an illustrious career. He was a very good journalist. He worked on Tirupati, Tirumala Devasthanam, and exposed the deed there. And he and Sai Baba, now editor of Varta, together worked wonders as reporters. Then he moved on to journalism. Yeah, moved on to teaching academic plan. In academic line also excelled very well. And most importantly, as information commissioner in Delhi, did a wonderful job. He exposed Prime Minister Narendra Modi that is bluffing that he has a degree, which he doesn't have. But all institutions, democratic institutions are standing by Modi, protecting him. And Supreme Court is also protecting him. Kejriwal has taken up the case and he filed a case in Supreme Court. It is in the court. But even court also is saying that degree details need not be given to public. Actually, right to information is as good as right to speech, right to freedom of speech. According to 19.1, it is given as a guarantee, a fundamental right. Even that is denied. And he has questioned it. He will stand in the annals of Indian history for exposing the Prime Minister. And we say constitutional democracy. What is constitutional democracy? Very different from ordinary democracy. Democracy is not just holding elections. In democracy means constitutional democracy guarantees the freedoms and rights of minorities and individual citizens. Not only it imposes limitations on the majority through institutions. That is constitutional democracy. So actually RTA is one of them. Many such institutions are there, but all the institutions are being compromised since 2014. Actually, Rahul Gandhi in 2019 elections has commented that Modi is a surname of people who break laws, keeping in mind Nirav Modi and Dalit Modi, who are at large, who are in London, living in London, who are escaping the Indian law. So there was a defamation case against him. He almost lost the case, lost his membership in Parliament. Supreme Court had come to his rescue. Again, he said so many things against the Prime Minister as the opposition leader. As the leader of opposition, he had to say things. And every time he said something controversial, there will be 10 to 12 petitions across the country. And they'll be taken up. Now, Supreme Court has done one thing. They have clubbed all the petitions against him and thought of treating as one petition and hearing the case. That's one thing going on. And the journalists also have no freedom. Journalists in India are two kinds. One is Modi journalism. That is called Godi journalism, Godi media. The journalists who are working in Godi media are more loyal to Prime Minister than Prime Minister himself. Prime Minister, when he went to America, in US, in Washington, at a White House press conference, a lady working for Wall Street Journal has put a question to him. Back in India, the social media, right-wing social media has been trolling her, and even newspapers started writing against her for asking a question. So asking a question is a crime in today's India. There is a case of Siddiqui, a journalist in Kerala who was working in Delhi. He went to UP to find out what happened when reports came that a Dalit girl was raped and killed. Well, on his way, he was arrested and put in prison. He was in jail for 2 years for nothing. Ultimately, he was released. But there are so many others. Modi dispensation is a knack of using Pegasus, a software brought from Israel, to put matter in the computer belonging to somebody without their knowing it. Like that, Varora is there in jail. Bhardwaj is there, Mr. Professor Bhardwaj is there, Sudha Bhardwaj is there. There are so many people who are in jail for no fault of theirs, no crime committed, but it was shown that they are committing crime. They are in league with China or Pakistan. They are getting money from abroad, like Sonam Siddiqui, Wangchuk of Ladakh. He was all right as long as things were fine with them, as long as he did not question them, as long as he did not go on hunger strike, as long as he did not agitate for statehood of Ladakh or to include Ladakh in Schedule 6. Once he started asking the government, once he started questioning the government, he became anti-national. But he was arrested and put in jail for no reason. His wife has appealed to the Supreme Court to release him forthwith. But things are, because Sonam Wangchuk is a famous person, because he was given Narcis Award, because he was a right activist, he is well known, it is coming as a news. So many others in the country who are suffering silently in jail without a relief. Bail is not given. In Modi's dispensation, the freedom of speech is as good as not there. Because the media is not free to write. The corporate which own the media are in the hands of Modi, so they control the media. The websites also, the social media also is dominated by writing socialist social media belonging to BJP. So much so, there is no freedom of speech. So Professor Siddharth Karilu is well endowed, well equipped to talk on these subjects, freedom of speech and constitutional democracy. I request him to now take it up and deliver it, please. Please.
Should I speak now?
Yeah.
Namaskar to my friend, Mr. Lakshmaya, and then our senior journalist, Sri Ramchandra Murthy garu. We are discussing on such a very significant matter, which is dealing with the life of every person, every citizen, and everything that what you can think about it. Democracy, whatever it is, or constitutional aspects. We have to discuss so many other things to understand what exactly this point is, this topic is. Now, I'd like to first start with the critical situation of Indian constitution and democracy. In the last elections, there was a serious discussion on the constitution. First time the constitution was in a central stage. I never expected so, never. But now in the last year, I really found it very interesting, successful to understand the constitutional aspects to every student, except most importantly, the opposition has understood the seriousness of the law, seriousness of the democracy, and seriousness of the constitutional consequences, constitutional requirements. So that was a very interesting discussion that happened in elections time. Then there was also accepted as one possibility of getting 400 seats in parliament. Then it was really apprehensive, very, very serious issue. If they can take 400 seats in a constitutional parliament, what will happen to this democracy? Was the question. Then I was also discussed difficult for me to understand what exactly it is. But luckily, in my view, the elections has really helped the people to protect the opposition. That was a very interesting situation, a constitutional situation, and it is very helpful for the democracy. That was very good situation, good thing that happened to this country. That's what I was very happy about that. But let us see what exactly happened to the right to freedom of information, freedom of justice, freedom of expression. The problem is freedom of expression is in a problem. Press expression is in trouble. What kind of a trouble it is? I would like to talk about the problem that has come up from the judiciary. Of course, they are trying to protect us to a great extent. Executive is the problem. Executive with the decisions and activities of executive, we are in a serious problem issue. Then only thing that should have saved us the situation was Parliament. So whether Parliament is helping us or not is the question that we have to understand. The law works through not Supreme Court, but by the Parliament. Now the Parliament, who has to decide what should be the law, what should be the bill, why it has to go to Parliament, why the people are discussing or not discussing. These are the very, very important questions that we are totally ignoring. The reason why I would like to say this point is, recently there was a serious amendment to the 1918 article, the right of Act of RTI. This was seriously amended. And when such an amendment is proposed in the Parliament, what was happening? The entire opposition was on walkout, and nobody knows whether the discussion happened or not. Then the bill was passed. The bill was passed, and the president has agreed on that, and the law is before you. Data Act, it is called Data Protection Act. It is before you. 2023 was the opposition, was the making of law, and that law was discussed by the people, not by the Parliament. That's a very unfortunate situation. And then whether it wanted the opposition to represent the problem or to discuss with the government or the opposition or the other aspects, are they doing it? That was my real various problematic issue before me, and I'm really worried on this point. Then before that, before I explain the implications of this new Data Act, how it is dangerous to the freedom of press, expression, and the journalists as a what is it? It's called as a profession. As a profession, it is in a problem. Now, if you remember, recently, most of the organizations of journalists, they have made a representation to the concerned minister of the government of India. And the minister, when the minister was asked to explain the situation that they are worrying about it, but the government did not even take the point and explain what it is, but they did not. And then the recommendation, not the representation of the journalists, how it was in what kind of tone The tone is, this is, we request you, please consider our applications, our petitions, and these are the serious issues. Kindly look into this. This is the kind of thing that was happening in our recent times of that journalism that is happening now. Then the questions were around 100 questions. 100 are serious questions. They're situations. They are situations of failure of or violation of freedom of speech and expression. Every point of the situation was explained by the journalists and their organizations. But till now, it was not answered. And they are not even ready to demand it. That is what my worry is. They did not even ready to demand, no, we would like to go on strike, we will oppose, we'll do the band. There's nobody to talk about this. That was the serious worry that I'm really seeing it. Then before that, I'd like to say, because I was working as a Central Information Commissioner for 5 years, I was given a position, not a position, I have to say position, as a Supreme Court judge level. As a Supreme Court judge of level, though I cannot give the judgments that can be accepted by the Supreme Court. No, I can only give the judgments in second appeal to the governments in the form of a judgment which can be taken up to High Court and then again to the Supreme Court. That was the situation. But what exactly the situation was, the demand for information was rejected. Most of the times it was rejected. Then I was giving some judgments which are very serious judgments. Some judgments were discussed and quoted now by the senior journalist, serious journalist also. He spoke about this very serious points. I don't want to explain again this. There is no need. But what I would like to say is, when a person in the position of a Supreme Court judge is now reduced to the level of a secretary or as deputy, what is that? Lesser than security level, if you make them a small officer who can decide the question of whether right to information can be accepted or not. Is this the RTI that we wanted? We fought for it. And it's now 20 years now. For the last 20 years, it was working. It was really working very well, in spite of some problems right here and there. But the parliament, what is it? What has done? The parliaments are the statement of the parliament's law. Parliament made a law which amended the constitution, not constitution, RTI. But what I want to explain this point is, there are several state legislatures, they made laws on right to information. Every was conflicting the others in most of the states. Then Supreme Court, then the Parliament thought, and the then government of India, they wanted to make a central law of RTI for all the people, for all the states. In fact, that was a very good point, a very good decision that was taken by the government. And according to that, under what right a state has to give a law on RTI, why the center has to do the law? The parliament has to do that law. That was the question. The answer was, it was because a fundamental right, because it was part of Article 19(1)(a), because it is part of Article 14, because it is part of Article 21. That means the very most important three laws are together, through rights were together. And because of that, a central legislation, that means the parliament has made such a wonderful law, so that others cannot change it, others cannot amend it, others cannot reduce the power of the RTI. But what happened? It was changed. It simply changed by a simple legislature in the parliament, without amending the constitution, without amending the 19(1)(a). 19(1)(a) is violated. The way 19(1)(a) is violated is a very, very serious question. And only one person questioned it, and nobody has questioned so far except some journalists here and there. Parliament, nobody has questioned it. Parliament simply agreed whatever is proposed by the state. I mean the center. Then what happened? There are commissions. There are several commissions, 11 commissions in RTI, under RTI in Delhi. I was one of them before this amendment was done. The amendment was proposed in 2017. And in 2007, the proposal was sent to me also, because I was a Central Information Commissioner, along with 11 people, along with other 10 people. Nobody opposed it except me. And he questioned me. The other people who were around me, they questioned me. Why are you are anyway, you are going to be completing your term as 5 years, whereas in the proposed change or amendment to the RTI, it will be reduced to 3 years. 3 years of 3 years of support, 3 years of duty as a Central Information Commissioner. Fine, you can reduce the people of the Central Information Commission's term by reduction. Okay, that's not a problem. But the other problem, very important problem, is why did you reduce the status of dealing with the right to information? That's a serious question. Then second part, another very important part, is the amendment to the parliament will also amend the state legislatures. How can a state legislature make another RTI to reduce they're supposed to do that. If you want, they have to reduce that. But they did not do that. For the entire government, for the entire state, entire the nation, they made a new law. And because of that law, the weakness of the right to information has been perpetuated. This is the problem, very serious question, and nobody questioned it. And when I was asking for this, luckily the government has postponed the proposal of legislature, the amendment of RTI. They were waiting for me to retire. I waited until I retired from the position of 5 years of position as a Supreme Court judge level. But I have to leave it. I have to, because 5 years is over, I have to step out. The moment I stepped out, the proposal has advanced, and then it went to the parliament, and parliament simply accepted it. Nobody questioned it. I was also told that there are around 550 commissioners whose power and the status has been reduced from what was they working to very, very, very lower level, like secretary, the deputy secretary. That means they have not amended the law totally, but they removed the power of the entire RTI. That's a serious question one should understand. And I'm really worried about this point. How do I make the people understand that this RTI is very important law? This is the question. Then the next point I want to discuss is the most important point is Data Act. Very important Data Act. Why it is important? In the name of data protection, in the rescue, in the what is it I should say? In the accuse them, it is the proposal of changing the law, protecting the digital law of privacy. In the name of privacy, they are protecting the data. And how they want to do that? That was proposed by the commission, because the commission was headed by the commissioner, former justice of Sri Krishna. Sri Krishna Commission has discussed it, and they said certain exceptions have to be given. Without all those exceptions not allowed, there will be difficult in the name of protection of the data. It will affect the freedom of press also. So that is the question that was raised by the luckily the commission has given a correct proposal. Though I was opposing on certain aspects, the commission was not giving sufficient support to the people. That was my question. That's a different thing. I'm not discussing on that point now. Then the commission has suggested certain exceptions to the journalistic activities. Then what is it called? Is journalistic supposition. They reduced it. They removed it. Then I'd like to, before that, I'd like to say that there is another very important former justice of Delhi High Court, Delhi Chief Justice, AP Shah. AP Shah gave a very, very important propositions on Protection of Data Act without attending and without attacking the freedom of speech and expression. But do you know what happened? The government has rejected these two propositions, these proposals. They simply made the law without any exceptions, without any exceptions. And that's a serious danger that we are now before him, before the people, before the government. It is before you. What do we do? And that's why I told that 1,000 judges, the journalists, 1,000 journalists questioned it to the minister of the government of India. They know that it's a serious representation. But what did they do? Nothing they did. And it is now continuing. Luckily, 2023, though the law is made in 2023, the rules were not made till recently. Now the rules are made. Rules are very serious rules. The rules are so serious than the law itself. That is another problem. Then what happened? They have not started it. They have not commenced the implementation of this law. I'm very happy about that. It is that people are thinking about it. But people should understand that they're ready to be implementation. That's a danger of implementation is before you. Then, because of some opposition, some kind of apprehensions, they're not starting it. But what happens if they start it? What will happen to Supreme Court's judgments on freedom of speech and expression? And I'm talking only about RTI. You think that I'm only talking about RTI. Really, I'm talking about RTI. But the most important danger is available now is under the Data Act. In Data Act, there was one small proposal that is in section 44(3), third part of the section 44. This says if there is a conflict between privatization, not privatization, privacy and information, right to information, privacy will prevail. Privacy will prevail. That means what? You can't get the information. Even that information which is useful for opposing the corruption, in the name of privacy, they can cover up the protection, they cover up the corruption also. That is the danger. We are supposed to understand this. And then before I go to another important Supreme Court judgment that helped us to a great extent to protect the freedom of justice, right to know, not right to information alone. Right to information, right to know. There are two different important aspects of this right. The right to know is part of right to live. Right to live. It's part of right to live. Unless I know the knowledge, have some knowledge, I know some things on democracy and all that. How do I participate in elections? How do I participate in elections without knowing the information I'm supposed to do that? I'm to understand that. It's a big question. And the question was not sufficiently discussed until 2002. The very, very important date happened that remembered is 2002, the judgment of Supreme Court. Through a judgment of Supreme Court in 2002, right to information, right to know has been really established. It is not through Right to Information Act 2005. It was under Right to Know under judgment of Supreme Court in 2002. The people don't understand the significance of this law, this kind of judgment. Very, very interesting judgment. If at all we are saved now today, see, we are still feeling that we are saved or safe, it is because of this judgment, 2002 judgment. What was 2002 judgment? It says that people should on their own, the representatives of the contesting persons, contesting candidates, they have to on their own should explain that how many crimes he has committed, how many financial problems that he has created, and how many degrees or education he has. These 3 points they are supposed to answer. And they are giving affidavits. They are giving affidavits, and it happened because of 2002 judgment. And without 2002, do you know what was happening in previous government of India? The parliament has made a law. Do you know what was that law? Even after listening to or accepting the judgment of Supreme Court, the parliament made a law saying that under such a judgment, we need not give that information about criminals, the financial aspects, and the educational issues. How can the government do such kind of a law? And unfortunately, most of the states also, most of the parliaments also, not parliament, most of the parties have accepted it. I'm really surprised at what will happen to this country. Then again, the two small professors who do not have any power in dealing with the constitutional issues, he simply made a pill. Through a pill, he said, you just give the information about the education, give the information about criminalities, and give the information about financial issues and levels. It's a simple question. I'm not saying that I'll take back the money or take the finances, or I will not send you to jail. I'm not asking all this. I want only the information. That's the question. And the Supreme Court really very, very supportive to this concern, and then they judged it. They judged it in a very, very proper way. Then it has earlier to 2002, it was taken back to Parliament, and Parliament rejected it, and the Supreme Court took it again. And once Supreme Court took it once again, explaining that it is the constitutional requirement to give the information about contestants, then it was given. That is before you now. It is a real right to information that was available in 2002. But whereas the legislature has made in 2005 another law, which was amended and further amended, and it was further amended by Data Act, and it is affecting everybody. But luckily what happened, one more positive point I'd like to explain is, the Supreme Court, after 2002, in 2020, and in 2023 recently, they said that you have to give all kinds of information also. The affidavits have to be given again. And you have to give the entire information about the, what is that it is called? Bail. Bail petitions is not a conclusion of criminality. It is not conclusion of thing. But what is happening in the government, in the executive today, anybody, if he gets bail, he is free and he can talk to you and he can, contest. But now he will be in the jail itself. We do not know how long. Ramachandra Murthy Garu has explained how serious was the situation. And then the Supreme Court in 2025, recently, they said that every information about the bail applications and other information also should be given. So what? You will give only information. What will happen with that information? Because they're now they're in the jails only. Bail will not help the jail. Taking out of the jail, they're not helpful. That is the reason why I want to explain that judgment of 2002, as supported by the Supreme Court recently in 2025, we have to protect it now again. We have to ask for the protection. We have to ask for fighting. We have to fight for the protection of the information that is available, that is supposed to be available on their own. Please understand the difference between the right to information and right to know, and the decisions of the judgment. Do you know what happened? The judgment makes everybody to give information on their own. Please point out, on their own they have to give that information. Then in Parliament in 2005, there is a provision, section 4. Section 4 says, yes, they should give information on their own. But if they don't give information, there is no provision available in the RTA Act. Whereas under 2002 judgment, you have to give the information. There is no choice even to go in appeal to other higher courts. You cannot. Whereas RTI, you have to wait thousands of years, hundreds of years perhaps, and you have to ask for that. And another problem under RTA was pendency. Thousands of commissioners are appointed, not appointed at all. I can give you numbers, so many numbers about that. But I want to explain, this is the danger that we are going to see as a violation of freedom of speech and expression, right to information, right to know. I'd like to just conclude by reminding the history of what is it called? Magna Carta. Magna Carta, do you know what Magna Carta in 2015, in 1215, 1215, so many years back, 800 years back, what was stated there? What was declared by the total India, total country, not India, the whole world wanted to know, to file a right to petition, a simple right that was given by the Magna Carta, right to petition. If I don't have right to petition, there is no right to life also. And similarly, the right to information is having its roots in Magna Carta and 2005 Act also, and in the 2002 judgment also. You have this kind of principle available through this 1215 Magna Carta. Now, how do we protect our rights now in 2025? How do we protect our constitution? How do I protect our democracy? Is the question. I think this is the question I want to raise, and you have to discuss about it, think about it, and do whatever that we can do, we should do. Thank you very much.
Thank you, Dr. Sridhar. According to Dr. Sridhar,
Sir,
2023,
sir, me face not visible, sir.
2023,
Sir, you can move right, sir.
No,
right?
I'm visible.
You are visible.
Yeah, Murthy
Am I
garu.
visible?
Murthy garu, okay.
Am I visible?
No, sir. No, sir. Half of your face is hiding, sir.
No?
No, sir. Just please move this side, sir.
You have to change your camera.
No?
This is
To some
okay.
extent.
This is also okay. Half of this. Okay.
Okay, continue.
Now it's okay. Now it's
Okay.
Okay.
According to Professor Sridhar, 2023 was a very bad year for Indian democracy. That was the year when the Parliament were passing bills, watered down RTA Act, and also played with Election Commission of India.
Yeah.
The appointment of election commissioners earlier were done by a 3-member committee, which included Chief Justice of Supreme Court, Prime Minister, and Opposition Leader.
Right.
Chief Justice of Supreme Court is removed, and now Prime Minister and Home Minister.
They changed again.
It's like appointing any IAS officer at any post.
True.
So they are behaving like that only.
Yeah.
We don't have a session now. We have all sessions. And this quarter, Sridhar can speak on RTA alone for 5-6 hours because his mind is full of RTA. He has done so much work. He has given so many judgments, no other commissioner has given.
dates and okay. And then any day. Sorry. Sir, please continue, sir.
So, the RTA, which was brought in 2005, thanks to Sonia Gandhi and Manmohan Singh, was watered down. The Election Commission is now aiding and abetting vote chori, as is happening in Bihar, and they are threatening to apply the same rule in all the other states. So elections have lost its credibility. When Narayanan was president, he said the Election Commission had more credibility than judiciary, but not anymore. Now its credibility has gone down very much. So the Parliament is passing important bills, and the opposition is not there. The important bills are pending, opposition is working out. So it is fault with both opposition and ruling party. Both members of Parliament are not behaving responsibly. They are passing bills without knowing what is there in that. That's the reason why it is happening. So I think we can have another section on this subject because it is a vast subject. Journalists have no freedom. That has to be discussed separately. And what Ambedkar said about freedom of expression. Why 1902 article was brought in as a reasonable restrictions on freedom of speech. Freedom of speech is not absolute. It has to have some restrictions. Why? To explain all these things, we should have another section. Now I thank Sridhar for doing excellent job. Thank you.
Sir, now it's a time to interaction. Anybody have a questions, please ask.
Hmm?
Situation is very grave.
Sir, please introduce yourself, sir.
Okay, sir. Okay. I am Group Captain Dinesh Chandra, based in Lucknow, Uttar Pradesh. Retired from Air Force in 2017. Situation is grave. Through this RTI Act, I collected the information and fought within the Air Force and got things done in my favor. Had it been this time, in the present time, I would have been jailed. I would have been in jail. Like we are every day seeing to whomsoever government wants, it is putting him on jail. Like recently, Mr. Wangchuk of Leh. Now, how do we see to protect ourselves, like Professor Sridhar had rightly raised the question. But if we fail in that, which I feel we may not succeed, otherwise, in other words, what will be the pariniti, means end result of that? Because law is not protecting the normal person. So it is leading to anarchy and lawlessness. Don't we think ultimately the battle will be fought? I don't think during my time, but it may be. The battle is to be fought on streets. Either, sir?
No, what is it? The point?
Point is, the way things are going, the anarchy is there.
Yeah.
There is utter lawlessness. While there is still something left to protect us in the name of Constitution.
Unless the people respond,
Exactly.
come do something, it is difficult otherwise.
Sir, now nobody is listening to people. We are seeing in Leh, we are seeing in Assam, we are seeing in different parts of India. Who is listening?
Even the voters are losing their right. Voters.
Exactly.
They don't even
So
go to vote. They can't even vote to vote. If that will happen,
exactly, they will reign in forever. Such forces will reign in forever. So ultimately, what is the solution?
Seriously.
When I am left on my own to fight my own battle, when there is no law, there is no one to protect me, then I will have to fight for myself with all my might. So what shall I do?
Good point. It's a good point. But what is the answer? What is the answer? Who will give the answer?
I know. We cannot answer, and we should not answer in straight words. It is my effort is, again, I should not say these words, my effort is. The question must go in everybody's mind,
Correct.
and
Yeah.
especially our next generation, which is not at all concerned about anything. How to introduce these things in their mind. Otherwise, they will face the head. There's no doubt in that. Thank you.
That's what I said. It is the danger.
Good.
It is the danger
Thank you very much.
before you.
I'm now request to other friends and guests should raise the questions if it is there.
Sir, I am from Himachal Pradesh, Engineer Ahmad Roj. We are grateful to you, sir. You have told us about the data protection bill and RTI, although the right to know also. But nowadays, the situation is very serious that the religious gurus, they are attacking using fatal language against the Honorable CJI of India. And why these are not being penalized? Is it the freedom of speech that even this Honorable CGI of India is not AIC this protected? And the second thing is that there is in the last few days the RTI information about the this education of someone is banned. That is called that the personal this information and is not being provided. And how do you can elect a person when you are not knowing the education of a candidate and all that, and that is being hidden. So I don't think that is also good. And the third question is that the welfare schemes are based on the database. If that is also being made hidden, then you tell me that how the welfare schemes are to be implemented if you don't know the this population this counting and all that. So this is my question, and what do you say about it, sir? Over to you. Thank you very much.
Your points are correct. And that is the problem we are discussing. That is the issues that were explained by Ramchandra Murthy garu. How the reasonable restrictions are available and how they are not unreasonably being used by the people. No, freedom of speech and expression and right to information, they are supposed to be properly used. But what I am talking about on the legal aspect, not the abuse of the aspects. On another occasion, we can discuss what is the effect of abuse. But what you have suggested is there should be reasonable restrictions. There is no dispute about it. But the problem is the right to information is weakened, freedom of speech and expression is weakened, and right to vote is weakened. That is the issue that we are supposed to discuss on the point that we are supposed to discuss today.
Thank you.
All the democratic institutions have been compromised.
Yeah.
Thank you, sir. Anybody is there? I think we have to close. Okay, sir. Thank you. Thank you very much, sir. This is, I think, the 66th lecture and 66. We finished, we completed. I think this occasion, Professor Sridhar Garu accepted our request and gave a beautiful, not I am saying lecture, it's a very heartful opinion, heartful thoughts to express before us. I think it's very useful to not now. It's very useful to in future also. Thank you very much, sir. I thanks to Ramchandra Murthy garu. I think he is a very democratic and a very human nature of journalist. I think two people are very much uh, seriously warn to the nation and people to react all those things what is happening, anti-constitutional, anti-democratic issues by the government, by the institutions, by the organizations, whoever, whatever it may be. I think it's a very useful lecture. Sir, Sridhar garu, if finish the 75th lecture, we have to organize one constitutional constitution conclave in Hyderabad in our CDS premises 2026, 25th, 26th. Tentatively we are thinking, but anyway, we are finishing the 75 lectures. We are going to have a conclave with all scholars participated in this Samvidhan Samalochan. Second thing, sir, we are going to have a publication of all lectures in the book form, and also we are going to put in YouTube available to all the people, all the world. That's why we are organizing lectures in English, because there's so many problems we have. North India, our friends, they didn't proper understanding of the English. Even South India people also they didn't. But it should be universal. That's why we are consciously organizing in English. Yes, sir, that is the thing. I thank two eminent people. And after this 75 lectures finished, also we have to have a one serious program. Then in this program, we are 7, 8 organizations in all India nature. We are also will be discussed in 2, 3 days, and what will be the situation, what will be further program, and what will be the. Sir, thank you very much, sir. Sridhar. Thank
Thank
you,
you very
Rama
much. Thank
Garu.
you very much.
Thank you all other my friends and guests and activists. Thank you, sir. Thank you.
Thank you.
Thank you.
Sir.